Thank you for tuning in to the Brock Eichler Talks podcast, where we explore and discuss today's trending legal topics. In this episode, we'll discuss a recent alert from Brock Eichler titled FTC Noncompete Rule Update. Last week, on July 3, 2024, the United States District Court for the Northern District of Texas, one of the courts hearing a challenge to the FTC's April 2024 non-compete rule, preliminarily enjoined the FTC from enforcing its rule against the named parties, but did not extend the injunction to any other businesses. The court indicated that it would be issuing a final order by the end of August 2024. Thus, as of now, every business in the United States, other than the named plaintiffs in this lawsuit, will be subject to the FTC non-compete rule on September 4, 2024, absent further judicial action. We have previously published alerts about the scope and import of the FTC rule and about the status of the lawsuits challenging the rule. Please see the show notes for links. Because the Texas Federal District Court did not issue a nationwide injunction, businesses do not have any greater certainty about whether the rule will go into effect and will likely not get greater certainty until a few weeks, or perhaps only a few days, before the rule's September 4, 2024 effective date. Wait and see becomes less of a prudent option under these circumstances. For businesses with executives not currently subject to a non-compete agreement, the business's leadership could consider whether to require its senior-most staff to sign non-competes before September 4, 2024. If the FTC rule goes into effect as scheduled, non-competes with executives will be excluded from the rule so long as the non-compete was entered into before September 4, 2024. In some jurisdictions, continued employment will be sufficient consideration to enforce the agreement. In other jurisdictions, additional consideration will be necessary. Making the decision, obtaining legal advice, and having compliance before September 4, 2024 will take careful planning over the summer. For nonprofit organizations, a careful review of the FTC's jurisdiction over the organization should be conducted. The FTC does not defer to the IRS tax-exempt determination and instead uses a fact-specific, two-part test that examines 1. The nexus between an organization's activities and its alleged public purposes, and 2. The ultimate recipient of the organization's financial proceeds, to assess the extent to which proceeds benefit public, not private interests. The FTC looks to both the source of the income, i.e., to whether the corporation is organized for and actually engaged in business for only charitable purposes, and to the destination of the income, i.e., to whether either the corporation or its members derive a profit. Conducting this analysis and consulting with the Board of Trustees will similarly take time over the summer. Businesses should also seek guidance about how the United States Supreme Court's June 28, 2024 decision in Loper Bright Enterprises v. Raimondo may change the likelihood that a court will enforce the FTC rule. That decision held that courts in general should be less deferential to the rules promulgated by federal agencies. To obtain legal advice about the FTC non-compete rule, including its application to your organization, please contact John D. Fanburg, Esquire, Managing Member, Chair, Healthcare Practice, Co-Chair, Cannabis Industry, at jfanburg@brockeichler.com or 973-403-3107. Keith J. Roberts, Esquire, Member, Chair, Litigation Practice, at kroberts@brockeichler.com or 973-364-5201. Rose Suriano, Esquire, Member, Litigation Practice, at rsuriano@brockeichler.com or 973-403-3129. Carol Grelecki, Esquire, Member, Healthcare Practice, at cgrelecki@brockeichler.com or 973-403-3140. J. Sabin, Esquire, Member, Labor and Employment Practice, at jsabin@brockeichler.com or 917-596-8987. This is intended to provide general information, not legal advice. Please contact the authors if you need specific advice. Brock Eichler, LLC is a full-service law firm based in Roseland, New Jersey, with over 80 attorneys. The firm is focused on the following practice areas: healthcare law, real estate litigation, trust and estates, business transactions and financial services, personal injury, criminal defense and government investigations, labor and employment, environmental and land use, family law services, patent, intellectual property and information technology, real estate tax appeals, tax and cannabis law.